Dismissed.
Online.
Mention. Look at one.
Right.
Third.
Third is B. Sharma, Learned Counsel for the appellant. This is an application, no, this is an appeal against the impugned judgment and order passed by the learned session judge Udal Guri, Assam, in sections bracket T-I, case number 13/22, by which the appellants have been convicted under section 302 and 201 IPC. Admit the appeal, call for the PCR. Ms. B. Buyan, APP, accepts notice, appears on behalf of the state. This is the matter. Give a date. Item 2.
He is also my meter. Name is not son.
Acha, this is also your matter.
Yes.
Legal aid counsel or what?
Legal aid counsel.
The earlier one was a legal aid. Acha, the earlier one also you put legal aid. Then you write out here. Ms. B. Sharma, legal aid counsel. Where is the letter?
It is along with the condonation petition.
Okay. Ms. B. Sharma appears on behalf of the appellant. This is an application. This is an appeal. Condoning. Okay. No, it's already spoken. This is an appeal against the impugned judgment dated 9/5/24 passed by the learned additional sessions judge number 2, Kamrup M at Guwahati, in sessions case number 99/2016, by which the appellant has been convicted under section 447/34, 325/34 and 302/34. Same order, huh? Same.
18-2. Obliged. Right to dear. Mention. Listing the complete. Oh.
Okay, so this has actually, it was filed in 2022.
Lordship, she is appearing.
It was under defect, in the defect
Yes.
3 years.
Yes, sir, Lordship. 5 to dear file. Item number 5.
Or 9-5.
I, on behalf of RDEP, my senior is out of station. I pray for an adjourned date.
What is your name, madam?
P. Brahma.
P. Brahma. Appears on behalf of Mr.
Ardev.
Ardev,
RDEP. He is out of station.
Learned Counsel for the appellant. This is an appeal against the judgment dated 5/8/22, passed by the additional session judge, special judge Pokso Sipsagar, in a special Pokso case number 65 of 2019, arising out of Nazira PS case number 277/2019, by which the appellant has been convicted under section 6 of the Pokso Act. Admit the appeal, call for the TCR, issue notice to the respondent, issue notice to the respondents. Ms. B. Buyan appears for the state, APP appears for the state. The appellant shall take steps, shall provide a soft copy of the appeal to the office of the PP, who shall thereafter
Steps over.
send the same to the OC of the concerned policeman for furnishing the same to the respondent number 2. The OC shall thereafter give a report.
Usi, may I know the name of the police station?
Nazira.
Nazira.
I've already in the order it is there.
Why?
That's why I've mentioned everything.
Must oblige.
That's all. This is the matter on give a date.
19-2.
I write Ms. B. Buyan, Learned APP, is granted 4 weeks time to file.
Actually, we have no papers, my lord. She is also without file.
It doesn't matter. 4 weeks time to file written objection to the application under section 389 CRP.
Your number to take details.
The applicant shall also serve copies of the appeal and the application under section 389 CRPC to the learned APP. You make that in the appeal petition. In both you put it all. And you also write one thing, wait. This appeal had been filed in the year 2022. Mustafa, however, it was in the defect stage for more than 3 years. Hence, the listing of this case 3 years after the filing of the suit. That's why they scaled the date. They will not. 22.
What's the place?
Huh?
Victor mentioned IA Civil 3735
No.
in Matter Appeal 52 public 23. It's an unlisted matter.
Item.
It's an unlisted
Oh,
matter.
you want to mention?
Yes. Unlisted matter. Lordship, may please list the matter today. Take up the matter.
What is the urgency?
I think it's a long pending. Yes.
Today?
Today.
IA or appeal? What is it?
IA.
For what?
In Matter Appeal for pending delay, maintenance and pending delay.
Yeah, that's why it will not.
It is a pending matter.
Yes, ma'am. That's it.
The other side will not know anything.
The other side is not representing the case till date.
Till date.
Yeah.
Then you are challenging the order of the family court.
Family court.
Yes. You're the husband or the wife?
I'm the husband.
Oh, you are challenging the maintenance order.
Yes.
Item 6.
Okay. Heard Mr.
A.K. Gupta Mad.
A.K. Gupta, learned counsel for the appeal. This is an appeal against the impugnment dated 30/06/2025, passed by the Special Judge Pokso Majuli in Special Pokso case number 7 of 2024, arising out of Jengrai Muk Police Station, PS case number
17 of
17 of
22.
2024.
Yes. First person. Page 4. Second paragraph. Step line. Second line. Right towards the general PS case number 17 of 22.
Okay, 2024. By which the appellant has been convicted under section 373, 376 bracket 3 IPC, arranged with section 4 bracket 2 POXO. The appellant was thereafter sentenced under section 4 bracket 2 POXO. White sentence.
With our lordship, and during pendency of the trial, lordship, he was there, and there is a miscommunication between his counsel and the appellant,
Convicted in abstentions.
for which judgment
Was arrested later.
Arrest.
You ran away.
lordship ran away. Now he is in custody, lordship.
Correct, because warrant of arrest was issued, you were caught after conviction.
Lordship.
Too much, your lordship. Too long.
To do. This is liberty, madam. You see, like I told you, the other some months back,
Madam.
there was a direction that all appeals which had been rejected by the High Court should be sent to the Supreme Court
Yes.
for taking up the matter by the Legal Aid Services Committee of the Supreme Court. So all cases were sent from all states. There was no question of limitation then. Criminal matter, that's the thing. I can understand,
No, no.
but then that is the.
It's too long.
At the end of the day, they are going to anyway allow.
Then I leave it to you.
They're going to anyway allow it. So I will best we take it up. Heard Mr. L.R. Mazumdar, learned counsel for the applicants who submits that there is a delay of 2245 days in filing the appeal against the impugned judgment and order dated 5/8/2019, passed by the learned Additional District and Session Judge Hojai at Sankardev Nagar in Sessions Case number 80 bracket N for Nagaland, /2010, convicting the applicant in absentia under section 302 IPC. Next part. The applicant's counsel submits that the applicant has, however, been arrested and produced before the court on 13/1/2025. No, on not 25. When? Well, on 13/1/2025. After 6 years.
Even after arrest also, he is not able to prepare this appeal, Lordship, for almost a year.
That is the difference. Why did you go to court? Why did you surrender?
Lordship, no, after surrender, Lordship,
No,
after
why?
surrender,
So
he
that is
was-
no excuse. That is no excuse. The thing is that there's no point
I know.
in even if we reject, it's going to be allowed anyway.
Right.
That is the problem. You know? We are his behavior as such. You can see he convicted in absentia, sentenced in absentia, then arrested 6 years later. That also not because he surrendered. He was caught on the basis of a warrant of arrest. Luckily, he was caught. Now we are lucky that there's nothing much. I mean, since it's a matter of personal liberty, I think we'll see whether there was. But your behavior itself is, it points to the fact that you are guilty and hiding from something. Anyway, whatever. Full stop. He submits that due to his poor financial condition, no appeal could be filed by the applicant earlier.
Rehana Begum sir. There are several accused persons.
There's one,
This, I think they have preferred appeal. Rehana
Only they
Begum, I
have
think.
preferred,
recall-
Lordship. I have instruction that others preferred appeal.
Then
It
what
is
has
pending.
happened? What has happened to those
It is
judgments?
pending in this.
Rehana Musaddar
Let us
Ali.
see. Let us see. Then maybe he also submits that how many were convicted?
Lordship,
25 seconds. So,
Page 25.
This Musaddir and all, I think Mosan Mia Asile, no?
Mosan Mia,
Yes.
only one. Two were convicted, others were released.
only Lordship.
What is his number? Criminal appeal.
Lordship, I have no instruction, but I'm sure that they have filed already.
He submits that out of the accused, only the applicant hearing and one Musador Musssador Ali alias
Who is more
Moson
Mosan Mia Kora?
Mia MIYA have been
No, no,
convicted
Mosan-
under
who
section
is that?
302 IPC. Further, the said Massador Ali has filed
So online.
an appeal before this court,
Lordship,
which is registered as.
Lordship, a number I have, I will collect.
Just I
Lordship
could
after-
recollect this name, Musaddar.
Okay.
I can give Lordship after some time.
So what do? We wait for some time, I think.
Lordship may list this matter. Their delay point.
Or delay.
Unless your Lordship condones the delay, then it would come up.
He's like now.
And admission stage, your Lordship.
Huh?
Same person.
But we don't know no, if it's really pending or not.
Yeah, let him get back to us.
ইয়াতে চালে পাৰিব
You just see Masudor Ali.
Sadr Ali
MUSSADOR. DOR.
LIS মোচন মিয়া আছে মোৰ মনত আছে সেইটো।
As sorry, more as sorry.
এই
Because
ছোট
if all the evidence has been decided there and decided, then we have got nothing to
maybe
decide.
pending
Then you'll have to go to Supreme Court or something.
19 Musaddar.
মোচন LIS মোচন মিয়া
It is, you want to know the impugned judgment?
19.
স্টেট ডিস্ট্রিক্ট কি
district. বুঝে।
If you give that.
ডিস্ট্রিক্ট हो जाए संकटदेव निगर निके
402 of 2019, that will be correct.
Son of Kiran.
yes same
Same. Twenty-one, 8, 2025.
Bill number.
So I think we'll list this matter,
condones the delay after condoning the delay matter for admission in this stage your lordship may list the matter
Okay. So we'll have to condone this delay. So what have I said? What have I said? And I have filed criminal appeal 402 of 2019, which is pending before this. So, sir, he accordingly submits that when the impugned judgment is also under challenge in criminal appeal 402 of 2019, the delay in filing the present appeal should be condoned. Ms. B. Buya, APP submits that in view of the criminal appeal 402 of 2019, the present application, she does not have any objection to the present application being.
delay is too long man.
No, madam, but
My lord.
when the thing,
Well,
judgment, you've got to, otherwise what will you write? Object, cannot be, how can it be? Yeah, she does not have any objection to the appeal being, the application being allowed. Good stuff. Next para. On considering the fact that criminal appeal 402/2019,
nalalage sir kalle
which is still pending in this court, and the present appeal having challenged the same impugned judgment dated 5/8/2019, passed in Sessions Case number 80/N/2010, we are of the view that sufficient cause for the delay has been made out. Accordingly, the delay of 2 to 4-5 days is condoned. A registry to list the appeal, along with criminal appeal 402 of 2009. After the vacation. I is accordingly disposed.
Suraj Prasad
Yes,
There is a IA for suspension of sentence.
okay.
IA 459.
459, okay.
Yes, petitioner is convicted under section 302 and 201 of IPC Lordship. And allegation is that Lordship, the petitioner has killed his own mother Lordship with a iron rod Lordship.
paperwork is ready in this matter
I know. He wants bail. You admitted to
Yes, extrajudicial confession.
to the husband of PW2.
Lordship, they
Confessed before him.
the statement which was made before the PW2 Lordship, it was not reproduce the what exactly what the accused said to him, Lordship. And it needs some corroboration, Lordship. Merely because of the statement of the PW2 Lordship, he cannot be Lordship convicted in this case, Lordship. And
What about your sister?
sorry, Lordship.
What about your PW1?
PW1 is a sister.
That's what. What about her?
Same thing, Lordship. The PW,
Admitted before your sister also that you killed your mother.
Lordship, but the
Do you have any
Which-
enmity with your sister?
conviction is based on merely on the circumstantial evidence, Lordship, and the link which leading to the circumstances and guilt to the said Lordship incident, Lordship, has not been fully established, Lordship, because the murder weapon was seized on the basis of a statement, but the extra copy of the statement has not been exhibited in the case. If your Lordship come to the statement of the IO, Lordship, that is PW6, Lordship, he described then the details of the investigation, what he has done, Lordship. PW6,
Yes.
page 27.
Yes.
He made a GD&T, thereafter on the basis of GD&T, Lordship, uh, he started investigation even without registering the case, Lordship. He seized the mother weapon.
How do you say that it was not registered? Everything he says here that he registered.
He cross-examination kindly come to page 29, Lordship. I was entrusted on 28/5/2022 to investigate the case, Lordship. Well, this incident, Lordship, occurred on 27/5/2022, but he was entrusted on 28/5/2022 to investigate the case on the basis of GD&T. I have typed the Azahar. Lordship, typed the Azahar. I have read over the Azahar before the informant. I have not written the word read over and accepted by the informant. On 28/5/2022, I have interrogated the informant, complainant, and other witnesses. On 27/5/2022, I have taken the statement of the witness Deep Saha. Deep Saha is PW3, Lordship. On 27/5/2022, I have taken the statement of the witnesses Lolita Saha. I have also taken the witnesses Kamala Prasad on 27/5/2022. Prior to the registration of Tinsukia PS case number so and so, I have recorded all the statement of the witnesses on the basis of GD&T only. Lordship. It is not a fact that I have not recorded the statement of Kamala Prasad. It is not a fact that PW2 Lolita Saha did not state before me that due to non-communication with my mother over phone, I, along with informant, younger sister Chanda Saha and my husband Dipankar Saha reached my deceased mother house. But the door was locked. We opened the door with a key which was hanged over the door. It is fact that this witness did not tell me that when we entered the room, we saw the blood stain on the hand fan. Except this witness stated that they have strong suspect that Suraj Prasad killed his mother and kept hide the dead body to some unknown places since his son is the only person present at the house with the mother. Proper interrogation will make case in come to an end, and nothing has been stated by this witness. I have not recorded any statement of the informant Sarita Deka under section 161 CRPC. I have not recorded any statement related to leading the discovery of the iron lordship. The dead body from where it
You have confessed to two of your sisters that you killed your mother. Why you?
that extrajudicial confession, lordship, needs to be some corroboration, lordship,
Not always.
because they are all on relative, lordship.
What you're also relative.
Yes.
You're the brother. You're the brother, PW1 is your sister, PW2 is your sister, and you have told your sisters that you killed your mother. Why should they lie to you? Or why should they make a false case against you?
Because they are on suspicion as stated by.
Oh, have you got any
Because-
enmity with your,
because
with your sisters? Any
If
enmity?
the petitioner was residing with her mother in a same house, that is why they had a strong suspicion that it is none other than accused who has committed the murder. Lordship. And there are other person who were also resided in the same compound, but they were not examined.
They have said that you confess to them.
Except that there is nothing because
Naturally,
the
what else do
leading-
you want?
that-
Do you want a videograph that showing that you are the one who killed?
because the conviction is merely based on circumstantial evidence. Lordship. Every link has to be established strongly, which pointed guilt to the accused person. Lordship.
Yes, that's all. Anything else?
And the
Weapon was seized.
weapon was seized, but said weapon was not sent to the
FSL.
FSL for yes.
I don't know why they don't
So-
send us all the time. Anyway, that is
And
the,
the MO, the PW4, the medical officer who examined that the deceased lordship, who in his statement stated that the injury caused by sharp weapon, but the recovery is a blunt object lordship. There has to be some. I don't know, lordship, at this stage, your lordship will consider this thing or not, because this is a appeal hearing and strong defense will be there to suspension of sentence. Lordship. And
strong defense, let it be there during time of hearing. Now though there's no
remaining, I leave it to your lordship.
yes, madam.
Well, our paper book is ready, your lordship.
No, on the ground of extrajudicial confession.
Lordship,
Where is that judgment?
there are, my lord. Oh, vast, lovely. There are judgments, my lord.
Give me that then. We can, you see, the problem is out here, your confession is to your two sisters. Both of them have, and even your brother-in-law also. So, why should they tell a lie? If you can tell us a reason why they should tell a lie, then maybe we can consider. Why should they tell a lie? Nothing is you have said against them. That they don't like you, or they are liars, or you know, nothing is there. Right. Heard Mr. B. Haldar, learned legal aid counsel for the applicant appellant, and Ms. B. Buyan, learned senior counsel and additional PP, assisted by Ms. M. Chakrabarti, Ardas, learned counsel for the respondent number one. Right. This is an application under section 389 CRPC, seeking suspension of the sentence passed against the applicant and for release of bail and release on bail. No, but just say, don't say and for bail, just say against the applicant pursuant to the judgment order dated 13/3/24 passed by the court of the judicial by the judgment dated passed by the additional session judge -2 bracket FTC in sessions case number 150 bracket T 2020 under section 302 IPC. The applicant's counsel submit that there were no eyewitnesses and the conviction has been based on the
2009-11
extrajudicial confession
262.
made by the applicant to his two sisters.
Nobody open sign.
Was the further the weapon that had been used, that had apparently been used, that has alleged to have been used for the crime, was not sent to the FSL for examination. That's all. Anything else?
And recovery on the basis of the accused. The exhaust statement has not been exhibited in this case. Lordship.
Huh?
The statement made by the accused, which lead to recovery of the dead body.
He also submits that the statement made by the applicant,
Hmm.
which led to the recovery of the axe,
Hmm.
Act.
Or dead body, Lordship,
which led to the recovery of the dead body from the drain,
from the drain.
has not been exhibited. Next, Ms. B. Buyan, then APP on the other hand submit that there that there is no whisper of any enmity between the applicant and his sisters, to have any to enable the PW1 and 2 make false to make a false case against the applicant. Further, the weapon was recovered. No, the dead body of the mother of the applicant was recovered from his disclosure statement. Correct?
Yes.
That's all. He also submits that in terms of the judgment of the Supreme Court in dash versus dash 2009-11 SCC 262. Kara?
There are 10 and thereafter I could not see. It was given to a friend.
As in sense of the Supreme Court has upheld the extrajudicial confession made by an accused as the same was believable.
Lordship, one more citation I'll be relying on.
Stop. Further, in the case of
In the case of Lordship Murthy versus State of Tamil Nadu,
reported in
2023, Live Law SC 679. Lordship
para,
Para 6, my lord.
the Supreme Court in para 6 has held as follows. Huh?
Hmm.
Next.
Live Law Pabo? 9. Mail. Oh.
We have heard the learned she accordingly submits that the application should be rejected. We have heard the learned counsel for the parties. As can be seen from the evidence, the applicant had confessed to his two
Mother.
sisters, PW1 and 2, that he had killed his mother.
Listen.
The dead body was recovered on the disclosure of the
Simran.
applicant. Further, the applicant in his examination under section 313 CRPC
Did not disclose anything.
has admitted to the fact that he was with his mother on the day of the incident.
See, he has not admitted in 313 statement.
He has admitted.
It is the learned trial court has observed that, but I have gone through the statement, Lordship. He has not admitted.
For that, you have got to go back to that court. We cannot decide.
Answer. You answered as that I was with my mother on the day of the incident.
At
That is enough.
36.
Huh?
36 of paper book. Look at that.
32.
36, 36. 36. On,
Yes, so he could not discharge his pardon.
so then, who's up?
He would have missed it.
On considering the above, on considering the fact that he has not denied that he was with his mother on the day of the incident, comma, and keeping in view the medical evidence adduced, we do not find any ground to allow this petition at this stage. The application is accordingly rejected. However, the observations and findings made by this court in this order will not be taken to be the final findings or observation of this court at the time of disposal of the appeal.
This matter may come up for hearing, then.
Huh?
Main appeal.
Yes, in the main appeal, you're right. On the prayer, the counsel for the parties submit that they have received copies of the paper book. Accordingly, list this matter for hearing on. Give it in. Is it in order is there, huh? Para 6.
Highly obliged.
Next, okay. Good. Filing number.
May I please lordship?
31 days.
Yes, lordship.
Miss N. Hassan, learned counsel for the applicant, submits that there is a delay of 31 days in preferring this appeal against the impugned
No, no, filing, no, 9, 10 filing.
judgment impugned judgment
No, no, 108.
Return from his left.
dated 8/7/2024, passed by the learned additional session judge cum special judge Pokso, Tinsukia, in Pokso case number 91/2023 under section 376 bracket 1 IPC. No, by which the appellant has been convicted under section 376 bracket 1 IPC and only
was an
56. Then why should it be Pokso?
No, there is no pokeshoot.
Huh?
She is a major girl, lordship.
No, okay. No, but why is it by the Pokso?
Oh, maybe during trial it has.
During trial.
It has been established she is a major.
Convicted under 376 1 IPC. Ms. B. Buyan submits that she has got no objection to the delay being condoned. According the delay of 31 days condoned, registry to list the appeal. I is accordingly disposed.
Highly obliged, lordship.
Please, your
Yes,
lordship.
so what has happened to respondent number 2?
Who appeared on the last occasion? No? Who appeared on the last occasion? Oh, you know, not on our side. Me.
The appellant shall take steps for service of notice upon the respondent number 2 in terms of the practice
Okay.
direction laid down in the notification dated 17, dated 15/3/2024. Have you taken step
Yes, lordship, steps have already been taken.
in
Only my
notification?
but Miss A. Begum appeared on the last.
Notice has been issued. Copy handed over to learned APP
Hassan
for
again.
forwarding to OC. Madam, yes, you have to take no report.
Kuntu police station.
Gogamuk.
Gogamuk. Disila niki. Gogamuk. We'll take fresh steps, man.
No, you because this has been handed over to you on 22/5/25 as per office note. Office note says copy of notice application along with petition and annexes handed over to the learned APP for forwarding to OC.
Probably I was not there, somebody else appeared.
Would be. We don't know.
Lordship will take steps, my lord.
Okay, right. Dr. P. Agarwal, legal aid counsel, is present along with Ms. B. Buyan, APP. As per office note dated 22/5/25, the copy of notice along with the petition has been handed over to the learned APP Assam for forwarding the same to the OC of the Gogamuk PS in relation to Gogamuk PS case number 144/2021. Ms. B. Buyan shall obtain instructions with regard to the same. As TCR has arrived, registry to prepare the paper book. List the matter, you were there.
Oblige lords.
May it please your lordship.
Yes,
Though it is shown as by order, I did not mention this case.
Anyway,
with
doesn't
name, my
matter.
lord. TCR has already been received, my.
paper book.
TCR has already been received on
Okay.
11/12.
TCR has received.
But it's not showing in the cause list.
Of one office note. I
No,
found.
no, it's, that's not the TCR, no TCR. No, there's no,
Office note.
there's no TCR, madam. Wait, wait.
11/12, one office note. I think.
Has already been raised in the hundreds. There is another appeal. That's criminal appeal number
Oh,
J 100 of.
Okay, right.
They're like
Miss,
spicy.
Miss M. Barman, learned Amicus Curiae is present along with Miss B. Buyan, learned AP.
Yeah, mojito.
As per office note
steps,
dated
sir.
11/12/2025, the TCR has already been sent to this court in connection with criminal appeal bracket J 100 of 2024. What about respondent number 2?
notice has dispatched.
Huh?
Notice has sent, my lord, properly report.
Same date. Page.
Hmm. Order to this will last order. Office note है सर अपना वो copy दीजिए.
As per office note dated 11/12/2025, the notice has been handed over to the learned APPSM for forwarding to the OC of the concerned police station. Accordingly, Ms. B. Boyan shall obtain instructions with regard to this. List this matter along with criminal appeal 100 of 20, criminal appeal J. Criminal appeal J along 100 of 2024
Last order to put very well.
on.
Slaughter.
Separate paper book may not be required.
That's
if
why-
that
that's
is
why-
declared.
that's why.
See, think of.
Declare.
Kudu police station.
Four.
Like this. Here is also issue regarding steps, my lord. I have gone through the records.
So TCR out here also is in another appeal,
Hello.
right? As per office dated 15/7/2025, TCR has been sent to this court in relation to criminal appeal number 75 of 2023. Accordingly, accordingly, leave this matter on transfer along with criminal appeal 75 of 2020. What about respondent number 2?
Not, sir, my lord. We'll take steps.
Wait, next para. As per office note dated 24/6/25, notice has been issued to the respondent number 2 to the OC of the concerned police station. Wide memo dated 24/6/25. Learned APP to obtain instructions with regard to the same. Then in the IA you write, I'll list the matter on, give a date, and then the IA you write, Ms. B. Buyan is granted 4 weeks time to file written objection to the application under section 430 BNSF.
My learned friend has come up with an IA, my lord.
Lordship already heard it on the 16th of this month, Lordship. I have filed a IA that
What is this?
That matter, my lord,
The ones of
the
push
charge sheet.
about the breaking the between the house. And then the.
Copy of the IA.
The statement is.
No, no, no.
is only